Hello, I'm Jan Newharth, Chair and Chief Executive Officer of the Freedom Forum. Welcome to First Five Now, a Freedom Forum conversation series exploring the complex questions our First Amendment freedoms face today, and featuring newsmakers who put their freedoms into practice. Today, we are joined by free speech expert Jeff Kosseff, who talks about the influential role that anonymous speech has played in American society. Jeff is the author of the new book, The United States of Anonymous: How the First Amendment Shaped Online Speech, which explores how the First Amendment has protected the right of anonymity and how the internet has changed the rules. This program is brought to you by the Freedom Forum, which is continuing its year-long celebration of its 30th anniversary after its founding on July 4th, 1991 by my father, Al Newharth. Since then, the Freedom Forum has fostered First Amendment freedoms for all. Our vision is an America where everyone knows, understands, values, and defends the freedoms of religion, speech, press, assembly, and petition. And now, please welcome our moderator, Lata Knott.
Thank you, Jan. Hello, and welcome to First Five Now. I'm Lata Knott, Fellow for the First Amendment at the Freedom Forum. Today I'm talking to Jeff Kosseff about his new book, The United States of Anonymous: How the First Amendment Shaped Online Speech. Jeff is an associate professor of cybersecurity law at the United States Naval Academy. He's the author of Cybersecurity Law, the first comprehensive textbook on U.S. cybersecurity laws and regulations, and of The 26 Words That Created the Internet, a nonfiction narrative history of Section 230 of the Communications Decency Act. The United States of Anonymous explores how the right to anonymity has shaped American values, politics, and our public discourse, particularly as technology has enabled people to separate their identities from their communications. Jeff, thanks for being with us today. And I believe the last time we talked, it was about your previous book, which was on Section 230. Can you tell me what interested you in the topic of anonymous speech?
So yeah, and thanks for having me. So the topic of anonymous speech really is an outgrowth of Section 230, because one of the big defenses of Section 230, or the justifications, is that what Section 230 says is that you don't sue the platform, but you sue the person who posted the content. And that makes a lot of sense. But what I saw in a lot of cases was that you often couldn't identify who that poster was. They either used Tor, or they used multiple VPNs, or they might be on their neighbor's unsecured Wi-Fi connection, and you can't actually track down who that poster is. And then on top of that, even if you could technically track down the person, the courts have set a fairly high First Amendment standard for being able to subpoena identifying information of online posters. And I found that really fascinating, and I wanted to look at why we have these protections and what the justifications for protecting anonymous speech are.
And what I loved about your book is that you actually really delve into those origins of anonymous speech and why it's important in American society. Can you walk us through that, like why the concept became so important to us, to the framers of the Constitution?
Sure. So anonymous speech really is fundamental to the history of the United States. Many of the newspaper columns and pamphlets that were written to justify the American independence were written pseudonymously or anonymously, partly because people feared for their safety or their jobs, but also because they wanted to really separate their identities from their speech, because their identities might cause people to think differently about the arguments they were making. And this went even past independence to the Federalist Papers, which Hamilton, Madison, and Jay published under the pseudonym of Publius. Again, I think that was primarily for really enhancing the effects of their arguments. And so that history was really fundamental to the Supreme Court when in the 1950s and 60s, it recognized under the First Amendment rights to anonymously associate and speak. And this really originated not in sort of a pure speech context, but in an association context. And this was a case sort of right after Brown versus Board of Education, you had the NAACP in Alabama really working hard to sort of implement the rulings of Brown versus Board of Education and to desegregate schools and so forth. And unfortunately, a number of the state officials in Alabama were very segregationist, some white supremacist judges and state officials. And what they did was they found a technicality in the NAACP's failure to register under the Alabama corporation statute, and rather than just say, okay, you have to file and pay a fee, the state sued the NAACP. And then, as part of, and the goal was to shut down the NAACP. But then, as part of that lawsuit, the state also issued a discovery request for all of the member names of the NAACP in Alabama. And so this is 1950s Alabama, and there's a very strong reason to not want to have your membership list revealed because they could face all sorts of retaliation, which wasn't just hypothetical, but it was very real and on the record. And so this goes all the way up to the Supreme Court, and the Supreme Court unanimously finds a right of anonymous association under the First Amendment. And that carries through a few years later when a Los Angeles ordinance is challenged that requires the authors of handbills and pamphlets to put their real name on the pamphlet or handbill. This is challenged by a civil rights activist who is distributing pamphlets calling for the boycott of a supermarket that discriminated. This goes up to the Supreme Court, and once again, they find that a right of anonymity, but this time under the free speech right. And the court explicitly looks at the history of anonymous speech in the United States and says, this is so fundamental to our history that, of course, free speech includes the right to speak and publish anonymously. And this has been reaffirmed by the Supreme Court, both by liberal justices, and I would say actually probably the most ardent advocate for anonymity has actually been Justice Thomas in a number of cases, where he even goes further than many of the liberal justices in saying that the First Amendment, based on his originalist interpretation, was meant to include the right to speak and publish anonymously. So that's basically how the court has recognized this right that's not absolute. And there are some contexts like campaign finance where the court does approve of certain disclosure requirements, but it's very strong, and it's stronger than most other countries in the world.
And so you've described this through line between how an anonymity was an important concept, like from the very beginning of the United States, and how the Supreme Court sort of took that to apply to as something protected by the First Amendment, right? But how has the internet changed, like, our conception of anonymity, the law around anonymous speech?
So it's created a lot of challenges because there's a lot of good and some bad anonymous speech. And there have been a lot of disputes over whether people should be required to post under their real names, or even whether a company should be able to try to unmask someone. So this really started to arise in the late 1990s. And I think there still is, but at the time it was really big on Yahoo Finance. Basically, every company had its own bulletin board. They didn't maintain it. It was maintained by Yahoo Finance. But the bulletin boards were where someone could go under a pseudonym. They didn't have to give their real names, but they had to register with an email address, and their IP address was logged. And they could post anything about the company's stock, their financial performance. And what you had was a lot of primarily employees of these companies going on and trashing management. And that doesn't sound by modern standards like really a big deal, but in the late 1990s, this was a sea change for these corporate executives because they were occasionally used to getting bad press, but they never had a situation where any random employee could anonymously go on the internet and post whatever they wanted about the executives. This was criticism that those in power were not used to. So what they started doing, and they did a lot of these lawsuits. They would file a lawsuit either for defamation or saying that an employer breached a confidentiality agreement, with no intent on actually getting money from the poster. But they would file it so they could use the subpoena process to unmask the speaker and probably humiliate them, fire them, make it difficult for them to get jobs again. And at first, so the way it would work is they would issue a subpoena to Yahoo and say, I want the IP address and any registration information for these posters. Yahoo at first in the late 90s, they did not um, notify the posters. They would just follow, if there was a subpoena, they would comply with it. That would start to change. But what happened was you had a lot of companies, basically, they would get the IP address and maybe an email address. And from the email address, they might be able to identify the person. But even if they only had an IP address, which is just a string of numbers, they could then go to the ISP and issue a second subpoena and say, okay, now I want to know who the subscriber is. And then they'd usually be able to unmask them. Yahoo got a lot of criticism for not notifying people. And then by about 2000, they started actually notifying the individuals. And then you started seeing the posters start to move to quash these subpoenas. And you had people like Paul Levy at Public Citizen and the Electronic Frontier Foundation and some other privacy groups start to really take an interest in this. And they would start arguing for enhanced First Amendment protections. And this never went up to the Supreme Court, but it went to various state courts and some federal courts, and they came up with some different standards. And so I won't go through all the elements, but they basically say that if you want someone's identifying information, you have to have a pretty strong case, and you have to show that you have a strong case. And you also have to fulfill some procedural requirements. And it's a high bar. It's not insurmountable. There have been cases where people have been able to satisfy those requirements, but it's basically the finger is strongly on the scale of anonymity. So you can't just use a subpoena to unmask someone who's been mean to you. You have to actually show that you have a viable defamation case or a confidentiality breach case, something like that. So that's been the main way. There have been some other laws that have attempted to impose requirements that certain people disclose their online identifiers. So California had a law that said registered sex offenders have to disclose their online identifiers, and those could be made public. That was struck down. So there might be circumstances where certain anonymity intrusions are justified, but the bar is pretty high under the First Amendment.
But going back to something that you said about how Yahoo originally was not informing people that these companies had issued subpoenas and tried to get their information, but eventually came around to that. It struck me, there's quite a few examples of that in your book where you have these third-party companies who they're the ones who are technically holding the information that's the key to these people's identities. And I think things have changed a bit, like, for instance, how Yahoo approached that, but you're essentially relying on them to sort of inform people that, hey, this company is trying to unmask you or to protect your information. What do you think of that?
Yeah, so I mean, I think the broader issue, and this goes even beyond just sort of the online poster issue, is that companies have a whole lot of very sensitive identifying information. And this really goes beyond the 1990s, and this goes to today, where and the New York Times has done great articles both about facial recognition and geolocation data that is pretty widely available from all sorts of companies. Data brokers can provide access to people's precise geolocation information. And that's all sort of outside to the extent that they're trading in this information on a purely private basis. That's really outside of the First Amendment scope because we have the state action doctrine. So it's really become an issue where we need to look at our privacy laws or lack thereof and say, how do we use these laws not just to protect sort of what we consider private information, like health information, which we do need to protect, but also how do we better safeguard identifying information so that people can operate anonymously and we can preserve the values that really underlie so much of our First Amendment precedent.
Now, to play devil's advocate for a second, some might say, well, why do we need to protect this right to communicate anonymously so much when people often use their anonymity online to, to troll other people, to harass other people? But can we talk about maybe the pros of protecting anonymous speech?
Yeah, so I mean, I think that there are a lot of people who can speak pretty freely under their real names. I would say I'm probably one of them. I'm a tenured professor, so I have the ability to kind of, with some limits, but I can pretty freely go out and say a bunch of things, including personal things or controversial things under my real name. That's not an issue. But there are people for so many reasons, whistleblowers, people who might be facing harms at work, LGBT teens. I mean, there's so many people who use the ability to speak anonymously. People who might have work pressures where they're not allowed to say many things without losing their jobs. We have people who are domestic violence victims. There are some domestic violence shelters that actually uh, help people learn how to use Tor to avoid being tracked by abusers. There are so many reasons why um, people, and I mean, it really goes back the uh, to the reasoning from the founding of our country, where people who need to have a voice but don't have the ability to associate their real name with that speech have very good reason to want to speak anonymously. Now, there are people who abuse anonymity. I write about that fairly extensively. People who do bad things anonymously. And what I would say for two things. First is that anonymity is not absolute, and even highly skilled people who are operating anonymously eventually will get tracked down. In my book, I profile someone who was a computer science major who used all sorts of anonymity technology to really embark in a pretty horrific cyber stalking and harassment campaign. And he was very knowledgeable. And he eventually slipped up in terms of his use of VPNs, and that allowed the law enforcement to be able to identify him. And so they will be caught. Now, unfortunately, they end up doing damage while they're operating anonymously. But I also think we have to look at the underlying causes of what's making them do these horrible things when they're anonymous. And I'd also say that there are a lot of people who do pretty bad things under their real names. And I would just point you to any random Facebook feed where Facebook has a real name policy, and that's their prerogative. Facebook is allowed to have a real name policy. But people who are operating under their real names on Facebook, I'll say, I mean, I've seen plenty of really bad behavior. So real names are not anything close to a panacea for the bad things that happen online.
This is very true. Um, and speaking to that, we have real names, and that's viewed as like, well, if we provide your real name, like you are no longer anonymous. Although I suppose it sort of depends on what your name is, right? And I
Mhm.
guess my question now is, what do we mean when we say like you're anonymous? Is it just the right to publish without your real name, or is it more? Is there more to it than that?
Well, so yeah, I think that's a great question. And in the book, I write about how anonymity and pseudonymity, which is where you have a pen name or something like that associated rather than purely anonymous, how both of those concepts are not binary. So I read about how it's really a culture of anonymity empowerment where people can control what level of identifying information that they post online. So uh, the on one side of the spectrum, nobody could even narrow down what universe of people the poster is in. I think that's highly unlikely because typically, if people are posting, they might give some clues. So let's say that you might say, I'm located in Washington D.C. So that narrows down the vast majority of the United States, but you still are not identifiable as you individually. Or you might say, I live in this part of Washington D.C. or I went to this school or something like that to give the universe of people who you belong to. You also might say enough where certain people might know who you are. And this was the case with a lot of our founding documents and the arguments for independence, where a lot of the people weren't totally anonymous. There were people in the know who were like, yeah, of course that's Hamilton. But it wasn't the average reader wouldn't know that. And then also, some people will remain anonymous to most people for a certain amount of time. So that happened. That happened with uh, Hamilton, Madison, and Jay, and really everyone. Most of the authors who wrote sort of important foundational documents is that anonymity helped with their effect of their speech and protecting them, but after a few months or after a year, people knew who it was. And that happens a lot with the internet as well. Sometimes it's self inflicted. I write in the book about some cases where people are doxxed after posting pretty controversial things, and they believe that they're anonymous, but they again give enough different data points over time where you can connect enough dots where it's like, okay, nobody else fits this profile except this one person. And we see that happen quite a bit.
Let's see. And, so far we've mostly been talking about the American conception of anonymity and how it works for us. Can you talk about how that might be different in other countries?
Yeah, so it depends on which country. It's a pretty wide range. So in a lot of Europe, it's interesting because Europe, um, they kind of view privacy the way we in the United States view free expression. For them, privacy is really a fundamental human right. So the anonymity protections in Europe often are more grounded in privacy than free expression. And so they're not as concerned about being able to speak anonymously, but rather, is there a violation of your privacy rights if you pierce the ability to be anonymous? In more authoritarian countries, anonymity is either prohibited or sharply restricted. So, China, for years now, for example, has had various requirements for people to register before posting online or using the internet. And they say they still allow pseudonyms to be used, but that's basically only if it's linked to a real name that's registered with the government. In my mind, there's not much difference between being forced to post under your real name and being able to post under a pseudonym and letting the government know who you are, especially if you're in China. In Brazil, anonymity is prohibited. Other countries have require, if you blog, you have to use your real name. So those requirements, I don't think would ever pass constitutional muster in the United States. They've mostly not been attempted, but I think given the very strong First Amendment anonymity rights, I think it would be very difficult to be able to withstand constitutional scrutiny.
So given that the level of protection for anonymity is pretty high in the United States, do you think there's room for improvement? Do you think there's certain things that lawmakers should take into consideration to continue protecting anonymous communication?
Yeah, so I think that there are two different aspects. The first is how the First Amendment is interpreted, which is harder to control because that's basically relying on judges. And the second is any legislative initiatives. So, in terms of the First Amendment, in my book, I write about how there are some, I think, some shortfalls of the First Amendment protections. They're pretty strong in civil subpoena cases for things like defamation. For criminal cases, they're not. It's hard to tell because there are very few grand jury or criminal contexts where the target even has the ability to try to challenge it. So we don't have very many published opinions, but at least um, the clues that we get is that the courts apply a lower standard than they do in defamation cases. And I think that in some ways you could see, that might be justified. There's a greater interest in identifying someone in a grand jury investigation. But at the same time, there's even more at risk of someone being identified. I mean, in a civil case, you could lose money. In a criminal case, you could lose your liberty. So there's a good reason to say, we want to make sure this First Amendment anonymity right applies to government requests in addition to private litigants. And the other area is copyright. We've seen, and this started like in the early 2000s when the recording industry was issuing subpoenas to identify people who were infringing on peer-to-peer networks. What we ended up having after a number of years of court battles was a standard that gives some First Amendment protection for allegations of copyright infringement when you're trying to subpoena people, but they're not as strong as in other areas. And that makes sense. I mean, copyright infringement itself, to the extent that someone's actually infringed copyright and it's not fair use, you can't say they can't be liable because of the First Amendment. But my concern is that when you're issuing the subpoena, nothing has been proven. There might be findings that it's not infringement, or the subscriber name might not be the person who actually infringed. So I'm concerned about that. And where it's really become an issue has been in the past decade, where it's not just been the recording industry, but it's been companies that own the copyright to legal pornography that's shared on peer-to-peer networks. What concerns me about that is that they often will issue the subpoenas and they have that same low standard. And the targets have a very strong incentive to settle because they don't want their real names to be attached to a case accusing them of trading pornography. There's very significant privacy concerns. So I think that the courts really do need to rethink the relatively low standard that they apply in copyright cases. Now, in terms of legislature or Congress, really, I think a national privacy law would be very helpful for a variety of reasons, not just for anonymity, because we have these pretty weak efforts by the states, which I frankly think are mainly leading to the increased length of privacy policies and not much else. They do some good things, like they give individuals the ability to request that their information be deleted. The problem with that is that first, it puts a huge burden on the individual to say, okay, if you want privacy, you have to send all these requests to all these companies. And the second issue is that the individuals often don't know which company has their information. So there are data brokers that have geolocation information. I work in this field and I don't know the names of all of them, so I wouldn't know who to send a request to. So I think that a national privacy law, while giving individuals the choice and the ability to have information deleted, I think that's a good step. But I also think that we have to have a dialogue about what sort of uses and collection methods and sharing we just won't tolerate. And we say this is prohibited. And I hope that we can have a national privacy law that does that and that incorporates concerns about anonymity to say, okay, one of the things that we care about is the ability for people to, within reason, operate anonymously online.
Oh, thank you. I feel like I learned a lot from the book, and I've learned a lot from you. And I think that privacy is such a growing concern for people, but it's so rare that we really link it to anonymity and the ability to communicate anonymously. So I think your book does a great job of that. The book is United States of Anonymous. And Jeff, thank you so much for joining us on First Five Now.
Thanks so much.
To all our viewers, We hope you'll share your thoughts about tonight's program via social media at the addresses listed below. The Freedom Forum will be posting a recording of this program on the Freedom Forum YouTube channel, where you can post your comments. And we hope you'll hit the like button on this program and others and subscribe to the Freedom Forum's YouTube channel for more programs and videos on issues related to the First Amendment. I'm Letha Knott. Thank you for joining us.